Good afternoon, ladies and gentlemen, and welcome to Australian Business Lawyers and Advisors' second webcast for the year. 10 employment laws every manager must know. My name is Joe Murphy and I'm the National Workplace Managing Director for Australian Business Lawyers, and with me today is my Sydney Managing Director, Lewis Izzo. And today we're going to talk to you about the 10 employment laws every manager must know. Lewis and I got together and decided that we'd do something, a bit of a bevy or a bit of a suite of topics. We're probably going to race through some of these topics with quite some speed, but we'll do our best to do each of them some justice. We only have an hour today, so we want to answer some questions as well, so we'll see how we go. What we do have to start is something we don't usually do up front, and that is a polling question. And the polling question is, do you trust your payroll systems to calculate your leave accurately for your employees? And we've asked this for a particular reason. If everyone can now turn to your polling and poll for us, and we'll have a look at the polling we've got here. The reason we've asked this is because it's a topical issue and it's something that comes up regularly for us. And the next thing we're going to talk about, and we might start talking about this, we move to the next slide and we'll talk about this leave issue, and then I'll come back to the polling results, is that we regularly find that the way that the entitlements around leave are currently framed in various pieces of legislation, the Fair Work Act and the Long Service Leave Acts around the country, is such that they're calculated in a different way, they accrue in a different way, and it is our experience that there's probably, well, we've yet to come across a payroll system that actually accommodates all of them accurately. Lewis?
Yeah, that's right. Hi, everyone. It's good to see you. It's my first time for 2019, unlike Joe, who's already got one webcast under his belt. Some of us are a bit slower off the mark, so it's nice to be with you today. That's right, Joe. I mean, we have a variety of different leave entitlements with different rates of pay. You've got personal and annual leave that look at base rates of pay. You've got other entitlements that might be paid out on different bases, whether that's, for instance, you've got things like notice of termination that might have full rates of pay. But really interestingly, you have rates of accrual that are different. When it comes to annual leave and personal leave, annual leave is an entitlement that's expressed in weeks. Personal leave is an entitlement that's expressed in days. Employees have 10 days of personal leave a year. Now, for most employers, in fact, all payroll systems I've seen, they calculate leave based on hours. There's historical reasons for that. But what you then need to grapple with is, well, if my payroll system's recording something in hours, how is 10 days of personal leave a year being recorded? How is 4 weeks of annual leave being recorded, or 5 weeks for a shift worker? Because that's the nature of the entitlement. And 10 days for one employee might be a different number of hours in a day than 10 days for a different employee. And you don't have to think about many scenarios before you come up with the examples: part-timers versus full-time, 12-hour workers versus workers doing 8 hours a day. But it's very clear, based on the current commission authorities, a day is a day is a day. And so employers do need to grapple with the entitlement under the Fair Work Act versus how the payroll system might be calculating it.
Yeah, thanks, Lewis. And I might break in just here with our polling results. And our polling results are around 66% of people said yes, we are confident that our payroll system, or we trust our payroll systems to calculate our leave or capture the leave accruals accurately. And that, look, what we would do is, the tip that we would have here is, don't rely on your pay systems alone, your payroll systems. The problem there is, as Lewis has already said, the accrual rates are different for the different types of leave. Annual leave is calculated differently to personal leave, and they're calculated differently to long service leave as well. And of course, the entitlements for long service leave are different across the country in different states and territories. So if you have national operations, you might find that someone's getting more long service leave in South Australia, for example, than they are in New South Wales for 10 years service. Don't forget there is cashing out provisions for annual leave. And those provisions for non-award employees are contained in the Fair Work Act, and of course for award employees in the awards, and you've got to comply with those requirements. I think what we would say about this tip is always call your advisor before you terminate and pay out entitlements, whether that's your employer association, might be the New South Wales Business Chamber, it might be Workplace Assured that you're a member of as well. Always ring them and check before you make those payments to make sure they're right. I know that some of our advisors, the opening line they say about payroll systems is that's an indicative amount. You've got to manually calculate it to make sure you're okay with it. Next topic's award coverage and compliance. One of the things I think the misnomers around award coverage is that people think, Lewis, that if you pay a certain amount of money that award will no longer cover the employee.
Yeah, it's a common misunderstanding that we see arise. They're paid above award, so the award doesn't apply. You might have an employee on $100,000 a year, and you might happily be sailing off into the sunset, assuming that really you only have to worry about your contract. That's not the case. Awards apply across industry grounds and also occupational grounds. So that is whether someone falls within particular classifications. And if someone falls within a classification, they can be award covered, notwithstanding the fact that they earn well above the award rates. And that means the award break provisions apply to them, award rostering provisions might apply, time off in lieu provisions might apply. All of those nooks and crannies that we see in the awards that sometimes employers have to grapple with, allowances, penalty rates on weekends, they will all apply if someone is covered by an award. And for some of these awards, the actual classifications, the gradings go very high. I mean, I know, for instance, the Banking, Finance and Insurance Award, it goes all the way up to divisional managers and subject matter managers. You could be talking about whole heads of departments being covered by awards in some cases. And so you cannot just assume because of someone's salary that they're award covered. What you need to do is look at the coverage clause to satisfy yourself whether they fall within the classifications and the scope of the awards coverage clause or they don't. And that's really the important point. And unless you're doing that, or unless you're going to enter into what's called a relatively complex arrangement, a guarantee of annual earnings, which the reality is most employers don't enter into those, you need to be conscious of whether the award applies.
Yeah, look, the guarantee of annual earnings is a trap. That is a specific statutory phrase. There's a definition in the Act. There are a whole range of steps that you need to take to ensure that there's a proper guarantee of annual earnings in place. I've probably seen two of them in the last, in the existence of this Act. I don't know about
correctly drafted. I've seen a number that actually that purport to be a guarantee of annual earnings, but actually ones that have properly been set up, very rare.
And that's different, of course, to a set-off clause. And we've got our next slides, we're going to talk in a little bit more detail about set-off. But set-off provisions will assist you if you are paying over award. And we're going to talk about that in a minute, how that works. But what that means is that non-monetary obligations still exist under the award. As Lewis says, you've got breaks, you've got consultation. There's a whole other range of requirements that are non-monetary under awards that still apply. And
importantly, even if an employee is earning above the unfair dismissal threshold, that high income threshold of $145,000-ish a year.
$145,400.
Oh, there we go. Yeah. I knew Joe would know the number off the top of his head. $145,400. Even if they're earning above that threshold, if they are covered by an award, they will still have unfair dismissal access, which is why it is critical to have an understanding of who is and who isn't award covered.
Yeah, look, absolutely. Just for clarification, $145,400 excluding statutory superannuation.
Yes.
And finally, this is really important because if you do not have award coverage, if you do have award coverage and you do not comply with the award, then you are at risk of a breach of the award and potential civil penalties, up to $63,000 per breach for a corporation and up to $12,600 if you're an individual who is the employer or a person involved in the contravention. So the tip here is don't make assumptions about award coverage, and particularly at the end of an employment relationship as well, when it comes to termination of employment, as Lewis says. Assess award coverage at the front end of the employment relationship, then you can understand what your obligations are, what you're paying the employee for, and you do all the right things.
Yep.
that leads us into offsetting.
Yeah, so there's the offsetting for something that's actually the law's been settled on for some time. It still appears to be quite a tortured concept and one which causes a lot of confusion. You'll see on your slide there that there's an authority back from 1989, which is really the go-to case on a lot of this in this area. And what it essentially said is when you have paid someone an amount of money in satisfaction of something, you cannot then turn around a day later, a week later, a month later, and say, oh no, that was also paid for a range of other matters. And what that decision pleading ECOB essentially said is if you are paying a ordinary rate of pay to an employee as their to satisfy their base rate, for instance, under an award or their standard ordinary hourly rate under the award, you cannot then turn around and say, oh no, but this is also intended to pay you for penalty rates on the weekend, or it's also meant to satisfy the first aid allowance that we forgot to pay, or it's also meant to satisfy night shift provisions. Unless you have actually said up front at the beginning of the payment that these are all the matters the payment is intended to satisfy. So if you are paying above award, that's great. You can use that to offset other obligations you might owe that you might not even know exist, but only if you've made that very clear up front. And so what we say to employers is you need a clause in your contract of employment or your letter of offer which essentially says that the amounts that we are paying you above the base ordinary hourly rate are intended to also satisfy all the other obligations we have under the award. And if you have that in your contract or letter of offer, you're in a much better position to avoid some back pay claim if all of a sudden an employee discovers they're owed a penalty rate at night or on weekend that you weren't aware existed. And the same goes for trying to see, to the extent available, whether you can rely on overpayments in one period to satisfy underpayments in another. None of this can be done unless you have an appropriately drafted clause in your contract that purports to do that.
And I think one of the things we want to just draw a distinction between here is we talked about guarantee of annual earnings. We've just talked about an offset clause, offsetting, set off. There's a whole range of terms for it. But there's also an annualised salary under awards. We don't want to confuse that with this concept yet again, but we have to mention it. And there is a concept under a number of the awards, annualised salaries, and it is an ability for you to pay an employee an annualised salary that will be able to be set off against the monetary entitlements under that award. Again, there are some requirements in the awards to satisfy that sort of an arrangement. We're not talking about that necessarily here.
And that is a very separate process. Yeah. And indeed, recently the Fair Work Commission confirmed in its annualised salary decisions that even though you might have annualised salary provisions that require you to pay 25% above the base rate, etc., they sit entirely separately with and do not infect or prejudice an employer's ability to go through your usual offset process either.
That's right.
So they are different ways of achieving effectively the same thing: guarantee of annual earnings, annualised salary, offset. 3 ways of trying to cover your monetary award obligations.
And the decision you're talking about was the annualised salaries decision of the Fair Work Commission in February last year. I think Vice President Hatcher was the head of the
presiding
bench.
member. Yes,
the presiding member on that particular decision, and he talks all about set-off clauses and talks about the fact that you can still enter into them from a contractual perspective, but there are particular requirements and particular concerns you need to be careful about the period at which you're offsetting that overpayment. The next topic is reasonable notice, and this is one that is one that employers could avoid if they did some basic updating of contracts, or at least regular updates with letters relating to pay increases and changes of title. Because what often happens in the employers where we see problems is that an employee might be employed for 20 years. They may have come in the front door on a particular contract, and they're now leaving your business for a particular reason, let's say redundancy, and that's when it hurts the most, because you're already going to pay this employee quite a few weeks' pay after 20 years. It's going to be, under the Fair Work scale, 12 weeks' pay. Then you're going to have to probably pay them their notice. And if you do not have a fixed contractual term, then the employee will be entitled to reasonable notice. And an old contract that's been sitting around for 20 years, there's a high probability that that contract no longer applies to that employee. It might, but there's a high probability it doesn't. And therefore, the courts take the approach that in order to give a contract business efficacy, it will imply into the contract a term of reasonable notice. The contract, I think, Lewis, you've said this before, the contract needs to be able to be terminated. It can't be perpetual. It's not an ongoing thing that goes on forever. If it doesn't have a termination provision in it, it must. And so they will import one in or imply one in on the basis that it is necessary to do so.
Yeah, and the other scenario is, so old contracts, we see that a lot. The other scenario is if your contract's actually just silent on notice, that's equally going to be problematic. And the courts will say, well, we need a provision, what's reasonable? And for a long-serving employee, it's not unheard of to have 12 months as a notice period. It could be 9, it could be 6, but it can be quite significant. So that's something that you do want to be conscious of. The only other thing is to be conscious of is this might not apply where you have a fixed term contract, because it may well have a fixed term and a clear end date. But in fixed term contracts, you need to ensure the provisions are very clear and you have a good understanding of when it's starting, when it's finished, and how it's able to be terminated.
The tip there is just to ensure you have up to date, relevant and compliant contracts of employment with all of your employees. So we've got another polling question. This is an interesting one. It's a question that comes up a lot.
Yes.
Oddly enough, can you extend a contractual probationary period? Now, we've obviously well versed in the answer for this one, but we might let the polling take it away. So if you could all poll away on your screens, that'd be great, and we'll come back to the answer to this after we deal with this next question. And this might drive your answer.
Yes.
Yeah.
Look, there's a point on your slide there about the probation period that's, I think employers don't necessarily turn their mind to these days. I mean, what's the point of a probation period in a contract? And that's a question not so easily answered in today's modern age compared to under previous industrial relations regimes. And the reason for that is under the Fair Work Act, all employees, doesn't matter who they are, no employee can bring an unfair dismissal claim within the first 6 months of their employment. Doesn't matter what your contract says, for the first 6 months, you can't bring an unfair dismissal claim. For a small business employer, that is one with less than 15 employees, an unfair dismissal claim cannot be brought within the first 12 months of their employment.
And it's important to note that you can't contract out of that. You can't shorten them, you can't lengthen them.
It's just the statute mandated position, 6 months, no unfair dismissal claims, or 12 months for small business employers. In that context, your probationary period doesn't really have a lot of work to do because the Act's already doing it. All it really does is sets out that, well, you might have a notice of termination provision that's kind of 4 weeks, or for more senior execs, 3 months or something. In your probation period, it might be shorter. But other than that, your probation period's not really doing much more than echoing the statutory provisions. And so it's worth bearing that in mind. It's good as a guide, because from a managing employee expectation approach, it helps people understand, I need to kind of prove myself during this period. Everything's on trial during this period. So it does have a guidance utility. But in terms of legally its effect, it doesn't really do anything separate to the Fair Work Act. So just bear that in mind. I do think in that context, there really isn't any point in having shorter probation periods, 3 months, not much point because the Fair Work Act sets 6 at minimum, or really longer ones. I think if you have a 9-month or 12-month probation period that doesn't align with your Fair Work Act period under the Act, that's a real problem because you may have managers lulled into this false sense of security, assuming they can terminate with ease at the 9-month point when, in fact, unfair dismissal access kicked in 3 months earlier. So it really should just be echoing the Fair Work Act provisions in my view.
Yeah, look, I think there is some value, as you've already said, though, in the concept of a probationary period from an HR perspective. It's not a legal one. It's from an HR perspective, it helps employees, if you said, it helps manage their expectations. They understand they've got to perform during the first 6 months of their employment, or 12 months if they're a small business. You might still call it 6 months. They might find if they get dismissed after 9 months that, they thought that they we're protected outside of the 6-month period, and there might be some tears about that, but that won't bother you if you're protected from unfair dismissal. But the other issue is that it really does help manage that expectation. It really does. And this issue about extending the probationary period is an interesting one. Now, we've got nearly 60% of people say you can extend a probationary period. And the general position is you can't.
Well, and certainly with unless you've got consent, a contract is a deal between two parties. Any provision of a contract can only be altered with consent. So your first position is, well, did you get the employee to consent? And even there, you may have some difficulty proving the consent is genuine and legitimate.
They might say the only reason I signed it was I didn't want to lose my job.
And if that was their choice, lose your job or extend, there's a real question about duress and whether indeed that the consent was genuine. Now, Joe, I've come across the odd employment contract that actually confers a right to extend probationary periods. What's your views on that?
Look, I think, as we've already said, it won't have any legal effect because the Fair Work Act provides those fixed 6-month or 12-month minimum employment periods. But if it's drafted correctly, you could do it. There's a little bit of acrobatics from a contractual drafting perspective to be performed, but you could do it. And it might be another way to manage someone's performance. But I think employees, when they first get their contract, probationary period still means something to an employee. So there is an HR value in having a probationary period in there. I think even if you've got 3 months, I've had clients who've called up and said, look, this employee doesn't want 6 months, they want a 3-month probationary period. And I've said, well, if you want, you can give it to them, and they're still not going to be able to bring an unfair dismissal.
Right. Doesn't really prejudice the employer, I suppose.
That's right. Yeah. So the tip there is use probation periods as an HR tool. Don't confuse it with the minimum employment period for unfair dismissals. Yeah.
Procedural fairness. I might kick off with this one. I think we've got a couple of slides dedicated to this. Procedural fairness, we've got this up here as one of the 10 legal things you need to know. It's not so much a law. It's not necessarily there's a statute that says afford procedural fairness. The reality is it is in many senses implied into a large number of contractual relationships. There are statutory provisions that expect procedural fairness be afforded, a bit like the Fair Work Act in terms of unfair dismissals. It is really a basic tenet of any relationship where you're about to engage in something that might have an adverse outcome for another party. And, it applies in the immigration sphere, it applies in when any kind of administrative body is making decisions. It's considered a fundamental right that all people should have as a matter of what the courts call natural justice. Procedural fairness in the employment context can be broken down into a few key elements, and they're set out there in the dot points. Obtain all relevant facts in relation to a matter before you head off to implement some decision. Interview any complainants and relevant witnesses to get an understanding of what people say took place. Then the most fundamental one is put the allegations to the person concerned. Give them notice of what it is they are said to have done and give them the opportunity to properly consider that and to respond to it. And in many ways, the opportunity to consider and respond to allegations, wrapped up in that, well, there's a few other things. They need to have sufficient level of specificity about what the allegations are, an understanding of when they were meant to have occurred, what was said, where things happened, because a generic allegation, let's say I make an allegation, Joe, you bullied me the other day. Well, it's so broad, it's so high level, it's very difficult for Joe to properly respond. He has to imagine what is it that I could possibly be referring to. Whereas, to be fair to Joe, to enable him the opportunity to respond, I really should say, on this day, you went and said all these mean things to me about my suit. It's not my problem that blah, 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 and I took offence to that, and et cetera, et cetera, et cetera. You need to start giving an idea of what was said, how it was said, all those kinds of things, then gives Joe a fair opportunity to respond. And he may say, well, the soup was terrible anyway, but that's bye-bye. So they're the kind of things you need to ensure. And then obviously consider the employee's response before implementing the sanction.
And just to tack on the end there, which is not on our list there, but the allegations need to be brought in a timely manner. So you can't sit on them for a long time. If you find that you're dredging up complaints from past years, past months, and there's no reasonable explanation as to the delay for bringing those complaints, then they might just be too stale to put to the person.
Yeah, and there's definitely an issue there that you have to work through. It will also depend on the seriousness and why it is that it hasn't been raised earlier.
And I think one of the tips that I always like to give people about procedural fairness is procedure is your friend. Procedural fairness is your friend. What it does is it gives you the opportunity as the investigator or the employer gathering the information to gather all of the relevant information and make a fully informed decision. So whilst procedural fairness appears to be fairness in favour of the individual, I have to say that there's a great benefit for the investigator or the employer in gathering all that information. And so our tip is don't be afraid to give people an opportunity to respond and even multiple opportunities to respond. And, sometimes this can be a problem where you think someone's bringing a vexatious complaint, or you find that you've already concluded a view about a respondent to a complaint that the individual has engaged in the conduct and you've got them. If that individual has raised certain concerns, whether it's the complainant or the respondent, and they haven't been put to the other person or addressed, that can be a problem that can undermine the outcome.
And what we've done here on this next slide is we've actually... We've extrapolated out the process for your benefit on this arrow. I sometimes call the golden arrow. I often tell managers, no matter what you are doing, whether you're giving a warning or you're terminating, just have this arrow tattooed on the inside of your eyelid, because if you follow this, you're in a much better position to land it at a fair and just outcome. Two particular things I'd call out on that. At the very beginning, you'll see there's a question there, employee not required for work but remaining on pay. Where a matter is very serious and you think that indeed it might be inconsistent with the employee staying on as an employee if the allegations were established, or there's just a question about document security or the employee, the investigation being somehow compromised if the employee remains in the workplace, you may want to consider whether you should effectively be informing the employee that they are not required to attend for work whilst you investigate. Now, you might commonly hear this referred to as a suspension on pay. It's effectively telling the employee they'll keep being entitled to pay, but they're not required to perform work for a period. That's available in the more serious circumstances or where the investigation could be compromised. The other one, support people, Joe. You'll see it's there. What's the role of the support person? How do they fit into it?
Well, there's quite a few things to say about this, and we'll do them quickly because we don't want to run out of time today. But the first thing is that there's not necessarily a right for a person to have a support person. But just be careful, because sometimes people have policies that do provide people with a right in their general employment entitlements or the employment environment to have a support person. So make sure you're complying with your policies in that respect.
Or an EA.
I have, and that was my next point, I have seen enterprise agreements that have a right for an individual to be either have a support person or a right to be represented by the union. And if you deny them that right, it could be a breach of the EA, so it can be very serious. So just be very, very careful about that. The last thing is lawyers as support persons. And, previously employers have taken the approach that, you're not allowed to have a lawyer as a support person. I don't agree with that as a general proposition, particularly for big businesses. Where you do have a person wanting to bring their lawyer along, as long as the lawyer understands that they're there as a support person, if they're happy to potentially be a witness in a case, then that's a matter for them. But they can come along and they can support the person and they can ask for breaks. And if they want, let them make a submission on behalf of the employee. It comes back to this procedural fairness point. You should take into account anything that the individual wants to put forward. You may discount it after you've heard it. And the process we've got up here on the screen, every time you find out a material fact or an allegation that is important to your decision-making process, you will have to go back to the start of the process. Now, obviously, if you've dealt with the majority of the facts and the circumstances, it's usually not an arduous process to go back to the beginning and run through that process again, but it does mean you need to go through, once you've got the facts, putting the facts to the employee, allowing them an opportunity to respond.
And the only two things I'll quickly add on this is just remember, if you are moving to dismissal, if you don't provide access to a support person, that is something that can count against you in an unfair dismissal case. So that's where you want to ensure that they're there. But secondly, and I have seen this in unfair dismissal cases that we have run, where there are allegations about certain conduct or where there are allegations particularly about accounts of events or honesty, make sure the employee is answering those allegations and giving their version of events and not the support person. Because if you are going to make a conclusion that someone's being dishonest, you want to ensure that it was the employee that gave their version of events, and they can't then turn around and say, no, well, the support person said that. I now accept that's not right. If you want to maintain an allegation of dishonesty, you really need the version of events to have come from the employee. And so that's something to bear in mind as well. But otherwise, I very much commend the golden arrow to all employers as just the number one thing. If you only take one thing out of today, do that in relation to any disciplinary process and you should be in a good position.
Well, not just disciplinary, it can be, bullying, it can be sexual harassment complaints, It can be harassment complaints, it can be any sort of circumstance in the workplace. The golden arrow will help immensely. Prohibitions on termination of employment. So when we talk about managing ill and injured workers, people like to have these benchmarks. They like to say, I'm safe after 3 months, or I'm safe after 6 months, or I'm safe after 12 months to terminate this person's employment. That is not the case, but it is important.
You're never safe.
Yeah, well, that's true. But it is important to understand what those minimum thresholds are. They're not outer limits that you meet and all of a sudden you're entitled to terminate the person's employment. They are minimum periods. Up here on the screen, we've got Section 352 of the Fair Work Act. It's cognizant to be aware of this particular provision, which when you go to the regulations, which is referred to up here in this particular section, 352, the regulations provide effectively that when you have an employee who is off on sick leave for an injury or an illness, where that person is off and you are considering to terminate their employment, you cannot do so for a minimum period of 3 months. It's an absolute minimum period. It may be a longer period if they are still in receipt of paid personal leave for that period. Oh, sorry, you've got this on the next slide. So we've got extend for more than 3 months, and that is where they're not on paid personal leave. But generally, you've got to remember that minimum 3 months.
That's right. So the paid personal, and it could be other forms of leave, but if you need to wait for all of that leave to be exhausted, if they're taking it before you then are able to move to dismiss without offending this prohibition.
We've also got this, just be careful of the 3 months over a 12-month period where you collect the absent days or the days that the person was unfit for work. It's quite a complicated process to work out how long that person actually was unfit for. There's no simple way to do it, but effectively a cautious approach would be to be able to have evidence that the person was unfit for 93 days.
That would be the safest approach to take, yeah.
It's probably not technically correct, but I don't think there's a technically correct approach to take. That's the cautious approach. Now, we did have a question here about minimum period of employment, and I think we were just talking about unpaid leave. We talked about minimum period of employment before in the probationary context, and it said, my understanding is that the minimum period of employment can be extended for a period of unpaid leave. Is that correct? And generally it is, but you've got to be cautious about that, right, because there are exceptions.
Yeah, so generally, if that 6 month period relates to service, and so a service is any time that you're working or you're on paid leave. So if all of a sudden you take an unpaid period of leave, that won't usually count for service, and so the 6 months can grow under the Fair Work Act for the purposes of unfair dismissal. But I would say a couple of things about that. One, just remember when we're talking about illness that you still have this prohibition on terminating anyone within the first 3 months of any absence. So bear in mind that that's a separate regulatory obligation you need to comply with. 2, is the employee taking some kind of leave with payment anyway? Just need to explore this. What about workers' compensation payments? What type of, how's that going to interact? So there are a couple of areas where it does get somewhat more complicated. If they are clearly on unpaid leave, they're not being paid in relation to the period, then yes, usually that will extend the unfair dismissal period.
And the Commission has held that a person who is on workers' compensation, that is in receipt of payments,
yes,
being paid, that is a period of paid leave.
Which won't extend the period.
That's right. It won't extend the period. I might, before we move on, we'll just quickly say that the prescribed absences, when we talk about this temporary illness absence due to illness or injury, are those that qualify for personal carers leave under the NES, so in that particular respect, and where the employee has provided the necessary evidence.
Yes.
Under that. Bullying. Now, we've raised this one because since the 1st of January, I was going to say July, the 1st of January 2014, the Fair Work Commission has had the bullying jurisdiction. Those provisions were put into the Fair Work Act and they commenced on the 1st of January. And that provided a statutory definition of bullying for the first time at a national level. And it provides the requirement that in order for it to be bullying, technically from a legal perspective, an individual or a group of individuals engage in unreasonable conduct towards a worker or a group of workers that gives rise to a risk to their health and safety. And there's some reasonably easy thresholds to meet there. An individual doesn't have to be a worker, then engages in unreasonable conduct, and unreasonable conduct, it's a little bit fluid, a concept, and it's difficult to say exactly what will be unreasonable, but it will depend on the facts and circumstances against a worker, and that can be a person who's a volunteer or a contract worker or a subcontractor, or a school student on work experience. In those circumstances, where that gives rise to a risk to health and safety, that's technically bullying. Now, I've certainly personally formed the view that it's a flawed approach to approach bullying concerns on a technical legal basis. If you are at the stage of doing that assessment, it's too late. You need to be more proactive, and that is proactive to conflict or perceived conflict resolution. You can't dismiss someone's concerns on the basis that, at a glance, that doesn't look like a reasonable concern. It does mean that at this day and age, with the bullying laws, with the workers' compensation laws, I'm going to talk about workers' comp next, and with the workplace environment the way it is these days, you must address concerns that people raise from time to time. And if you don't, there's a commercial and potential cultural cost to your organisation. That doesn't mean pleasing every employee every time they make a complaint, bowing to their concerns, but it does mean taking an approach of addressing the concerns, investigating the concerns where an investigation is warranted, and ensuring that your leaders resist the urge to react emotionally, particularly when the complaints or the allegations are alleged at them. Would you agree with that? Yeah,
absolutely. I think that the issue that we often find is that there is a sweep. It's not necessarily sweeping under the carpet. That's a bit more drastic. But where things really fall off the rails is whether there's been a few comments raised, a few complaints, and they go either unnoticed or undressed, and then they blossom into a fully fledged dispute. And by the time you get to that dispute and a full complaint with 10 different limbs and allegations, it doesn't matter what the outcome is, even if the outcome is no bullying at the end of it, you're still going to have claim. You're still going to have a very disruptive workplace and an issue that has blown up and requires legal costs effectively to resolve. Get in early, acknowledge concerns early, respond to them early, and you're always in a better position.
Yeah, and I think the other scenario we get is also the one where the employer or the manager immediately senses that a reasonable person would not consider the complaint to be a reasonable complaint, or that there's some a factual or reasonable factual basis for the complaint and it's easily dismissed. I think that's where I see a lot of errors occur.
And this is where you mentioned about processes being your friend. This is where an investigation is your friend, because if you know it's got no merit, the employee's clearly misguided, call it out. Tell HR, they've made this complaint, I think it doesn't have any real basis. So please, we should be encouraging that to be investigated, because it will promptly endorse the approach the manager has taken and allow the manager to continue to manage the situation. So I always tell managers in this context that investigation processes are their friends, because it actually helps to reinforce the legitimacy of the process being undertaken. So that's I think that's a very good tactic, is where you do think something's misguided, call it out, investigate it properly to begin with, and you'll find it effectively any allegations of impropriety squashed quite early in the process.
And the tip here is approach all bullying issues with a view to resolution, regardless of the realism or your perceived realism. Now, speaking of perceptions, it's one of the themes we're going to talk about here with workers' compensation. And one of the things with workers' comp is that it tends to fly in the face of the general understanding of business people, and that is, look, I've got insurance. It's not really an insurance. It's a mandated, almost a levy that you must pay in order to provide injured workers with financial support if they're injured in the workplace. So that's the first thing. The second thing is that there's also this understanding that, when someone suffers an injury, whether it's a physical injury or a psychological injury, that, we didn't do anything wrong, so therefore we shouldn't be liable. The question really here is, it's a low threshold from a workers' comp perspective. Is it a personal injury arising out of or in the course of the employment? Now, it doesn't say anything to do with the employer's done the wrong thing here, the employer's acted unreasonably, the employer, has failed in a health and safety requirement here. It does not elevate a claim or the requirement for a claim to be validated or accepted to that level. It is a low bar. And that low bar is simply, does it arise out of or in the course of the employment? There's lots of case law around this. We've got one case on the screen, and that relates to psychological injuries. Now, there have been plenty of cases since this case, but I like this phrase. If real and actual events in the workplace lead a person to perceive that the work environment is hostile, and as a result, the worker suffers a psychological injury, then that injury is compensable under the workers' compensation scheme. Now, that was a New South Wales case, but it can be applied in other states and jurisdictions. So it's really important to remember that if a person, from a psychological perspective, genuinely perceives that something that's occurred in the workplace causes them grief, and that causes them an injury, whether it's temporary or permanent, that's going to be a valid claim.
Yeah, and people will often like to trot out, what about reasonable management action? Well, yes, there is an exemption, reasonable management action conducted in a reasonable manner. If that is the event that gave rise to the injury, yes, then it's not compensable. But there's lots of things in the workplace that might not arise from reasonable management action. A good example is just a really high intensity workload. So you might have someone who gets an anxiety condition just because they are very stressed about high volume of work that just arises due to the nature of their role. That is a condition that can arise, not because of management action, but because of the nature of the work. A different example is, someone's being performance managed and they effectively contract a psychological condition. Okay, yes, that is something that's covered by the exemption. But there's lots of other stressors in the workplace that can give rise to psychological injury that might not arise from reasonable management action. And the defence isn't, but we acted reasonably.
No.
As Joe says, it's just a no-fault jurisdiction.
And it's also not, just to be clear, when you talk about stressors, these can be everyday stressors.
Yeah.
You need to take your employees as they come, meaning, and in the legal game, we've called it the eggshell skull theory, and that is, if they turn up and they have a weakness or a flaw that means that they'll be susceptible to this, whether it's an inherent one or one that's just temporary, and anyone can suffer from those, it's still going to be a valid claim. So the reason we raise this is not to tell everyone that you should just give up, but just to help everyone understand that when a workers' comp claim arises, don't jump to the conclusion that it must be a false claim because a reasonable person would not have made a complaint about this or would not perceive this to have been, an unreasonable thing for them. Reasonableness is not the test in those circumstances. So that's the lesson for workers' comp. And the tip we've got here is that approach all claims as genuine claims unless compelling evidence to the contrary. And the other part to the recommendation is a fast and appropriate return to work. I'm a big fan of getting people back to work quickly where you can. That means supporting them while they're off work, letting them know you care, and then getting them back into the workplace quickly. Lastly, workplace surveillance, Lewis.
Yes, so in New South Wales, and employers are becoming steadily more cognizant of this obligation, but there is actually an act that regulates surveillance in the workplace. Now, you might initially think, oh, well, look, we're not recording our employees, we don't have these funny cameras, and I don't have cameras in the change room, so on and so forth. Okay, good. But that's not the only kind of surveillance being regulated. So I don't necessarily want to focus on camera surveillance and tracking surveillance because there are requirements for those types of surveillance. But the more common surveillance being done in the workplace is computer surveillance. And what I mean by that is employers are providing employees with laptops, ICT facilities, desktop computers, and the employers retain an ability to review communications prepared, documents prepared on those systems. If you have an ability to monitor email communications or other forms of communications on your IT facilities, you are effectively engaging in surveillance in the workplace. Whether you like it or not, that's what the Act says. And you can only do that lawfully if you've done two things. One, you've given notice of surveillance. That notice has to be very prescriptive. It has to be given 14 days prior to the surveillance commencing or a lesser period that is agreed to by the employees. And you will see that the notice has to specify the kind of surveillance to be carried out, how it's going to be carried out, when the surveillance starts, whether surveillance is continuous or intermittent, and whether it's for a specified period of time or ongoing. And unless your notice does all of those things, and unless it is given for the 14-day period or agreed to or on commencement of employment, I think, as well, it won't comply with the Workplace Surveillance Act.
So, Lewis, if I have a contract and it says we monitor our systems...
Yeah, that would be insufficient. But I'm sure if you are most employers out there, you'll think that that is sufficient because you might call out expressly, we monitor, we do this. It does not tick off all those boxes. And where this is going to bring you unstuck is one of two places. One, there's fines that are applicable under the Act, but to be honest, as far as fines go, they're not really on the super scary end. In fact, given the scale of fines we're seeing in the federal system, these fines are not very high. But the other problem is if the email communications you have obtained haven't been obtained consistently with these laws, on its face, they are unable to be relied upon in legal proceedings. So if you get sued for unfair dismissal and you say, oh no, but I've got all these emails that prove the reasons that I had to let this employee go, they might not help you because on its face, they will not be admitted into evidence. Now, there's some exceptions to that, and there's some argument that can be had, but the starting point is evidence illegally obtained cannot be relied upon in any court or tribunal proceedings. And that's why we're really hammering home to employers, you need to ensure you comply with your surveillance obligations.
Well, there are two additional requirements here, and Lewis talked about there being two, but this one sort of branches off into two subsets, and that's about having a policy. So you have to give the notice. Now, we prefer to put that in the contract. It doesn't have to be in the contract. The reason we put it in the contract is because it's usually when they commence that they get it.
Everyone seems to get a contract at least.
They do, yeah. Well, just about everyone. But the other requirement is you must have a policy. Now, it doesn't need to be a bells and whistles policy, but it does need to provide how you're going to go about doing it. And it needs to at least include a basic description of what you're doing. The other thing about that policy is, and this is an interesting requirement, that it needs to be communicated in such a way that it's reasonable to assume that the employee is aware of and understands the policy. So you need to notify that policy to the individuals. Now, we say at the very least, you should give that policy to each of the employees, and you're best having a signature saying that I have read and understand this policy, and you've given them an opportunity to come back to you if they've got any questions about it. That's the absolute minimum that you would want to be doing. Ideally, though, you'd really be running some information sessions on it, or you'd have it as part of your induction process.
Absolutely. I mean, no matter how good you think your processes are, my experience is almost universally in unfair dismissal cases, the moment someone is being dismissed for breach of any policy, unless they have signed something saying they read and understood it, they'll generally say, I never got that. And that will be the default response. I never got that. I didn't know it existed, unless you have something there to rely on.
Now, just coming back one slide quickly, Lewis started out by saying that if you have employees in New South Wales, we'll expand that to the ACT. And
Yes,
I do remember seeing an article from you in late 2011 before you worked for us about the new ACT legislation that came in that year, which sets out very similar provisions, in fact, almost identical provisions and requirements to this Act. So when we talk about these requirements, they appear in the ACT Act as well. There is a consultation requirement.
Yeah, so I was just going to say on that if you own the ACT and you need to address this, please reach out to us, because while similar, there are one or two additional obligations. Unless you cover that off, then the whole point of going through this would have been pointless. So in ACT, we've got the New South Wales obligations up there, but it is slightly different. But we're happy to help you out with that if you need an ACT-specific policy.
There are other laws around the states and territories. Lewis referred to the fact that we weren't really going to go into tracking surveillance here or camera surveillance, and there are some different requirements that relate to those. They seem to be less of a problem, although I think tracking surveillance is going to become more of a problem as people start to track their employees via smartphones. There's a requirement to have a sticker on the phone, and there's a requirement also to give them the notice as well. So that's really important. And in some states and territories, you will need their consent to do that.
Yep.
If you're in Queensland, the requirements are very low. There's not many requirements at all. So the tip here is, if you want to be able to even look at your employees' work-related emails, even though it's your system, your email domain, all of that, you must comply with the notice and policy requirements of the relevant surveillance legislation. So that's the tip there. So what we might do, Lewis, is have a look at some of these questions.
Yep.
There's quite a few good ones here. The first question I've got here is, we have a department that works 4 9.5-hour days each week. We have previously received advice that 76 hours each year sick leave will suffice. Should it be 10 times 9.5 equals 9.5 hours each year?
That's an excellent question.
It is an excellent question.
Sorry, I don't know if you're going to say something.
Well, the only thing I was going to say is I'll let you address it, but I will say that without additional facts, we couldn't give a definitive answer on that right now, but Lewis will address the challenges with that.
Yeah, look, I love that question, which is why I'm just so eager to get at it, because the traditional approach of most employers, and probably your payroll system is currently set up, is, we'll give them a notional 7.6 hours a day. If they take a day of leave, we'll pay them for 7.6. We'll take 7.6 off their system. That's not the correct approach. Generally speaking, if you have someone working 9.5-hour days, if they're entitled to a day of sick leave, they're entitled to 10 9.5-hour days. For your business, that might mean, and I think I do need to rely on Joe's caveat, we need to know all the circumstances, but for your business, that very well might mean they end up getting 95 hours effectively in your system a year. And the same goes for 12-hour shift workers. If they work 4 on, 4 off, 12 hours a day, then their 10 days look like 10 lots of 12, which is 120 hours. You then end up into a whole world of pain if you actually have an employee change arrangements from a 12-hour shift arrangement to 8. You might actually have to change the way you accrue. But long story short, to answer your question, I don't agree with the advice you've gotten. I don't think it's correct based on the existing authorities as at the day of our webcast, which is the 12th of March, 2019, because the authorities are quite clear that it's 10 days, and for your business, it may be more than 7.6 hours a day.
Yeah. So if an ordinary day was 7.6 hours, and then it's likely to be 7.6 hours a day, that'd be 76 hours. But you can't work on the basis of hours. It is not 76 hours. The Act says 10 days. I know there are a lot of people out there right now saying this can't be right. This can't be right. It's got to be 10 ordinary ordinary hour days, and we think that that's 7.6 hours or 8 hours, but it's certainly not 9.5. Well, it is what appears to be a flaw in the Act. And if you do read the explanatory memorandum to the Act, it does suggest that it is a pro-ratering arrangement whereby a part-timer, for example, who works 1 day a week, will only get 20% of the full-time entitlement of 10 days. So someone who works 1 day a week would normally get, under the old rationale, 2 days per year of accrual. But the way that the Act is currently phrased, I think it's section 96 of the Act, it says you get 10 days if you're an employee. There's another section in that provision that says that casuals are excluded from these entitlements, so everyone else gets 10 days. And then the subsection below that talks about accrual according to ordinary hours. So I just wanted to come back to that because I think there's quite a few people watching or listening either now or in the future when they're looking back on this, and they're annoyed, enraged and concerned about the fact that their payroll system's not calculating it correctly. So the next question we have is, I think there's a trite one here. Sorry, I've got one we just answered. There's another one about personal leave. After the employee finishes his or her paid sick leave, can they go on annual leave if they are still claiming illness? In which case, do we have to wait 3 months after the sick leave and annual leave finishes to possibly terminate the employee? Good question.
It is a good question. And I think there's two parts of it. One, can they go on annual leave? Look, the short answer, in most cases, the answer will be yes. An employee has a right to request annual leave, and the employer can only refuse the request if the refusal is if the refusal is reasonable. In most cases, it will be unreasonable to refuse an annual leave request where someone is sick and not able to come in. Particularly if they're not going to be present in the workplace anyway due to illness, you would think in most cases the court would expect that you would grant whatever leave is remaining in terms of annual leave. So the first answer to your question is in most cases you probably do have to grant the annual leave. The second question was, well, then do we have to wait 3 months until after all the leave has been exhausted? Short answer to that is no. Based on the way you've worded the question, it's not exhaust all your leave, then 3 months unpaid. The test on our slide is the prohibition on termination applies to any absence that extends up to 3 months, or if you've still got leave left, then when the leave effectively expires. So it might be 3 months and a few weeks, could be 4 or 5 months, but once all that leave is expired and once you've gone beyond 3 months, then the prohibition falls away.
Another question here about surveillance, and it tends to go outside of what we've just asked here, and that is, what about an employer with a generic surveillance policy provides a third party with access to specified desktop computers? So I think the short answer here is making some assumptions about that question. There are various surveillance requirements around the country in the states and territories. Generally, there's state and territory laws. And there are workplace-focused surveillance laws, and so New South Wales, the Workplace Surveillance Act, similarly named Act in the ACT, but in other states and territories and in New South Wales and the ACT, there are general surveillance pieces of legislation that also cover tracking computers and cameras and listening devices. And it's important that you comply with the requirements of those legislation. And that will usually require, if we take it at its highest bar in any of the states or territories, consent.
Yeah, and the other thing you've got to be careful with there is if you're giving access to employees or their records to a third party, you might have Privacy Act issues because employers don't usually need to worry about the Privacy Act insofar as it relates to employee records they hold. But if you are then providing employee records to a third party, that third party does not have the benefit of the employee records exemption. And so they may, or you may, be in breach of the Privacy Act in providing access to a third party unless there is a consent regime in place. So there's probably one worth looking at the specifics of. And again, if you'd like, reach out to us and we'll have a look at it.
Yeah, definitely. And we might just finish on this question because it's another surveillance question. And that is, can you please talk a bit more about the tracking surveillance and the sticker on the phone? So I'll talk about that very
That's one of the later questions,
It is. And we'll talk about just quickly both. We've got people in the workplace and people not in the workplace who might be third-party contractors. In New South Wales, which has effectively the highest bar apart from ACT as those little additional requirements, you've got to give you 14 days notice or notice on commencement, or under the Surveillance Devices Act, you need consent. So the best thing to do is to make sure that the notice is in the contract, whether it's the employment contract or the contract for services. And then on top of that, if it's a car that's tracked by GPS or another device, it doesn't have to be a phone. I mentioned phone earlier. I don't want anyone to think it's
Any
limited.
item.
It can be an iPad, it can be a phone, it can be a computer. Anything that is tracked by way of GPS or another tracking device or other tracking means electronically, then it's important that that device has a sticker on it from the workplace surveillance requirements notifying the person that they, or I say sticker, that's the best way of it, has to have some sort of a sign or a notice on the device or the car, and you'll find cars that are tracked have little stickers on them, notifying the person that's driving that vehicle that that vehicle is tracked.
Yep.
That doesn't leave us any time to deal with any other questions. What we'll do is we'll have a bit of a trawl through the questions, and if we see any others that we might provide some written responses to, but that leads us really next to our quick summary. This is our schedule of the items we dealt with today. You will have access to the slide deck, so you can come back and have a look at these if you like, and you'll also have access to the footage from today. Now, we also run training, paid training for HR and operational employees. We do training for employees more broadly as well, but our more popular training is training you to be a better manager and to understand the law better, how you conduct investigations, how you performance manage your staff, managing harassment and legal liability in the workplace. We do these sessions mostly in Sydney, Newcastle and Brisbane. We've done them in Melbourne and we've done them in Adelaide as well.
And Orange.
And we've done them in regional areas as well, and we've got some coming up in regional areas as well.
Don't forget the regional areas.
I'm doing one down in the Murray Riverina, down Albury-Wagga way. Lewis is doing one over in Dubbo. And we've got them available in other regional areas in the coming
And
months.
I'm doing one in Sydney on performance management in the next couple of weeks. I think it's early April. So if you're interested in performance management in particular, look out for that one.
And if you want to find where that is, you can get that on our website, or you can register it at that email address. Well, that brings us to the end, Lewis, and thanks very much again for a great session.
Thanks for having me.
And thanks for tuning in.